All right. Good evening, everybody. Welcome to the Cards Right Now's Community Conversation series, the fourth and final one in our series. Today's community conversation is going to be the finale. We're going to be talking about compassionate release and beyond. So, for some context, in 2023, advocates convinced state legislators to expand medical release eligibility to provide opportunities for more sick and aging people to exit North Carolina prisons before their death. So, I thank you for joining us to learn more about the status of that expanded eligibility and more ways we can expand access in North Carolina. Now, the Decarcerate Now Coalition continues their fourth annual vigil out of the North Carolina Governor's Executive Mansion. We are standing and showing solidarity with more than the 30,000 people who are currently incarcerated in North Carolina. This effort has built momentum with support from organizations and community members like you from across the state. Thank you for that. And so this vigil is a part of a demonstration, a call to action. It's a public platform outside North Carolina, outside the North Carolina Executive Mansion. This is comprised of small, rarely rotated group of people demanding that Governor Cooper use his clemency power and all other means to decarcerate North Carolina immediately. So if you would like to learn more about the vigil, you can join us at our website, decarceratenownc.org. And without further ado, I will turn it over to our speakers. Daniel, take it away.
Awesome. Thank you, Tim. So today's conversation is about medical release. And I should first say that my name is Daniel Bose. I am an attorney and a member of the Second Chance Coalition, the Decarcerate Now Coalition, and a big part of obviously our effort, and especially in regards to the Vigil for Freedom and Racial Justice, which is in its last week at the Governor's Mansion, as Tim said, is the governor's use of commutations, is the governor's use and through the agencies of any sort of administrative power they have, and then also calling on the legislature to extend greater power to the state to use whatever means necessary to release people who, in many cases pose no risk at all or very little risk to the community, but remain in cages. And so, this is an issue that becomes more and more pressing every year because, as anybody on this call knows, we have a rapidly aging prison population. And so those individuals are not only suffering loss of liberty, but now are dealing with health and other issues that have aging, but in a cage, and in a circumstance where, this has come up many times in our conversations before, the broader context is that people are suspicious when you ask for help, and that's for anybody in the prison system. And so especially when people are older and have a lot of those problems that may be, undiagnosed for a long time, they're often met with complete callousness. And so, there are efforts by advocates to not only change the legislation, not only change the governor's willingness to power that they already have, but also, change the tone of the whole situation to provide more compassion and more actual care for individuals who deserve it. So our first panelists, well, we have two right now, Yvette and Luke. Yvette, as I know her as a member of many coalitions, as the executive director of the Wilson Center, as I think I met you 2.5 years ago when you first came down. And, it's amazing at the Wilson Center how much in such a short time, how many policy issues y'all have really gotten into the center of, whether it's driver's license suspensions and broader sort of legal financial obligations issues, or in this case, medical release. So really, one, want to thank you. And two, want to give you an opportunity to talk about first, how the Wilson Center comes to this issue before I switch over to Luke.
Thanks so much, Daniel. And thank you so much to everyone for being here tonight and for having me. Again, I'm Yvette, and we came to the table sort of early on with our colleagues at Disability Rights and some other organizations, really to kind of see, what we could do both legislatively and non-legislatively to get more folks out of prison, particularly those who are aging. We came in with sort of the knowledge and the understanding that people age differently and faster in prison often. And so while, people are considered older adults, often at 65 years old, outside of prison, it doesn't make sense to apply that same number in prison. And oftentimes, because of how people age, people at age 55 already have a lot of the same chronic illnesses and medical issues and cognitive issues that folks have at like 10 years older when they're not in prison for lots of reasons. So we were part of this coalition who sort of looked for really practical and logical changes to the medical release bill, and we didn't get everything we wanted, but we there were a couple very significant changes. I'm happy to talk about those changes now, Daniel, or to let others talk about it as well.
Yeah. Well, can I allow Luke to introduce just sort of how disability rights partners with y'all, and then we'll
Yeah.
switch directly back to that. Luke.
Great.
Yeah, hey everyone. My name is Luke Woolard. I'm an attorney with Disability Rights North Carolina on our criminal legal team. Myself and my supervising attorney, Susan Pollock, got really into this issue because it directly involves folks with disabilities and folks with disabilities who are incarcerated, which is pretty much what our team exists to do, try and handle and advocate for people with disabilities in sort of all aspects of the justice system. This really seemed to us, number one, from just a human dignity standpoint, good to be releasing folks who are no longer a risk and are, disabled or, possibly terminally ill at the end of their lives. And made sense. One of the few issues that really we can sort of sell as a win-win to everybody. Didn't make sense to us that the prisons were paying a lot of money in medical care to keep housing these people that didn't need to be housed there, care that could have gone to other people, younger people who maybe don't qualify but still have disabilities and need medical care. Frees up staffing in a prison system that's really redlining and has been for a while now in terms of their staff numbers. They've got a significant number of vacancies. And really saw an opportunity to try and at least open up the eligibility pool to allow DAC sort of a little more freedom to try and let these folks out, ease prison populations, give some resources back that can be used elsewhere, and get folks out who really, don't pose a risk. And I think in a lot of cases are looking at spending the last part of their lives, letting them do that outside of a prison context and see their family and have a little bit of dignity in that part of their lives. So that's, I think, the why of when we came into it. And I'll turn it back over to Yvette for sort of the nuts and bolts of sort of what we've been trying to do and I think are still trying to do.
And Yvette, can you, as you talk about the nuts and bolts, can you add in how the Wilson Center advocated these issues and sort of, just a sausage of the legislative process as much as you can?
Yeah, absolutely. And I'll say that we came to this table, we're at the Wilson Center for Science and Justice at Duke Law. Because we're part of the university, we can't technically really lobby. So we came to the table as sort of a research and sort of data resource to the coalition. And I think that's the role that we ultimately served on the coalition. And I'll say, it was really interesting. We, as a group, sort of explored, like I said, all these sort of different options. And I think, we weren't sure whether we'd really be able to make a change legislatively. And we were sort of thinking about other practical things we could do, like trying to get the prisons more social workers and fill more vacancies for medical staff. But at some point, we heard that there was a Republican, Warren Daniel, who was interested in this issue. And that sort of was a huge opening for us to very quickly put together some changes and sort of negotiate back and forth about, sort of the, we had much more in here that was ultimately adopted. But the two significant changes that came about. One, so I'll just taking a step back, the eligibility for medical release remains the same. There are 3 categories that somebody can fall into, and if you're in one of these categories, then you're eligible to be reviewed. The first is being permanently and totally disabled. The second one is being terminally ill, and the third is being geriatric. And we can say a little bit more, Luke and I, as we go on about what those definitions are and what those categories mean. But the two biggest changes is one to the terminally ill category. So it was that the person had to be diagnosed with a terminal illness that was expected to end their life within 6 months, and it's now been raised to 9 months. So a very moderate change there. The bigger change came under the geriatric category, and it was at 65 years and older that somebody is eligible, and now it is 55 years and older. So those were the two significant changes that came out of this. Yeah, and happy to sort of talk about those definitions because they're not very clear. And yeah, just, to be honest, I don't think this is a very well written statute and it's confusing. And I'm not even sure that it is fully understood. And, there are really questions about whether the criteria before and whether now it will be actually, accurately applied. Yeah.
When that, as I understand it, that was in this year's budget, which is not too far from having went into effect, right? So, has this? What sort of have you seen? And I guess this question is for both Luke and Yvette, from the agency in terms of actually using this broader definition. What have you seen their approach be, and what has been the impact on people and families?
Yeah. Well, this went into effect December 1st, so it hasn't been in effect too long yet. I did recently go and meet with the head social worker at Central Prison and sort of talk to them about their understanding of the new criteria and the new changes. And I will say that they're aware that things have moved from 6 months to 9 months. And they're also, it seems to be that of the three buckets, the one that has been used the most, maybe almost exclusively, is the terminally ill bucket. So there's just still questions about, again, whether the agency has been applying this accurately, and actually using the criteria for using all three of the categories rather than just terminally ill. Not quite sure about that yet. Yeah, and I also see that my colleague Ben Finholt is here and is raising his hand. So I'm not sure if you have something to add to this point, Ben. That'd be great.
No, I don't have anything to add. I actually have a question for you and Luke, which is I'm wondering if you all could talk a little bit just about sort of the process of working with Senator Daniel, right? And just sort of what was Daniel Bowes referenced sort of sausage making earlier, but basically, like, what were the pinch points? What were the sort of things that you all had to negotiate on? Like, where was there pushback? I'm just wondering what the different sort of like pieces. I mean, any legislation is a piece of compromise, right? As a general matter. And so, what were the compromises that both sides were discussing as you went through the process?
Yeah, and I'll just add there's a third change that's significant as well, or maybe significant, before answering your question, Ben, in that the person has to fall into one of those three buckets, and they also have to be incapacitated to the extent that they pose, and it was no risk to public safety, and now it is no risk or low risk to public safety. So the bar is not quite as high and not made quite as impossible as it was before. And so, Ben, your question is about sort of, the different sticking points, and yeah, we can talk through that. Luke, I'm going to give you a chance to speak as well.
Yeah, I was going to mention that low or no risk just because that was, I think, a big thing that we got out of this, because I think you could put, an Eagle Scout who was born yesterday and has no history beyond that in front of, someone from DAC, and they might be able to say that person potentially holds a risk. So the low or no risk, I think is big and is just going to really expand, who is able to get further along in the process and maybe get in front of the committee. I will say that we do have folks up at the legislature lobbying for the rights of people with disabilities, which does mean I am one step removed, I guess, from the sausage factory floor there. But I can say, and if that correct me if I'm wrong, I think we went in asking, sort of looked at the data, and this is data put out by the Sentencing and Policy Commission, and they said, looking at when do we see recidivism start to fall off in people, and how does that, inform sort of what we are trying to ask for, right? We wanted it to be policy based. We didn't want to go in and just say, can you imagine your grandfather doing a crime? No, of course not. Let's reduce, the number. And so what we found was, studies are pretty clear that old people above the age of 50, much less likely to recidivate than any other group. Folks convicted of B1 through D felonies, less likely than anyone else really to recidivate. People who have served longer amounts of time in prison, very low, like have the lowest recidivism rates. Longer amounts of time being, determined as, 2 years, over 2 years, folks who have served. And we felt like that really applied to a large number of people within the aging prison system. So I believe we sort of started our asks there. I don't think, Yvette, that we started, or at least there was conversation about starting even lower than 55 to get people just considered, knowing that, the eligibility is only the first hurdle that you have to get past. Certainly, we knew we needed to do something about that absolutely no public safety risk. I think we wanted to try and get that restriction on the felonies taken away, because as right now, as I understand it, you still got a restriction. If anybody's had an A, B1, or B2 felony, they're just not eligible at all. No matter how long they've been in, no matter how well they've behaved, no matter what sort of disability they're dealing with or disease, they're just not eligible, which, is a shame, really takes people out of eligibility without any consideration of their individual circumstance. So those are the three sort of things that I remember as, things that we sort of had to compromise on, our realistic goals that we felt were really data driven and that we were asking for and needed to compromise on. Yvette, I'm sure I'm missing some stuff, so if you want to jump in.
No, you did a great job. That's my recollection as well. And I think we also, so geriatric is defined now, right, from 65 to 55. But the person has to not just be of a certain age, but they also have to suffer from a chronic infirmity, illness, or disease that has progressed such that the inmate is medically incapacitated and is also determined to pose, the no or low risk to public safety. And there are not lots, but there's a handful of states that don't have such a stringent requirement for older adults. And I think we were looking to make some strides there. So to sort of remove some of the really high bar of the incapacitation piece and the chronic infirmity and illness. And I think we were looking just to also include folks that are, have aged and are, as a result of aging, are more fragile and also have, of course, are not posing the same public safety risk that they did when they even came in, whether they did or didn't. But and so we didn't get that, and that has remained the same as well.
If I could, before I open it up to anybody on the call who has a point or wants to ask a question, to respond to Ben's point a little bit, I think there are different kind of legislative campaigns. And so I think this was the type where you had the advocates had good relationships with a specific senator and a powerful senator, and, knew that he may take some sort of humanitarian effort, but was not going to sort of take sort of a risky effort. Like he was going to use his power as far as he could without getting too risky. And that there wasn't really, that the agency was, sort of up in the air about anything at all, having their hands full with extending limits of confinement. And so I think that the good side of that is it's a little bit sloppy because you're trying to stay on the top of a runaway train. And it's amazing that the advocates have actually got it through the budget process as sort of late breaking, but quickly as they did. And now I think that it's up to the advocates to point out, to work with agency staff to talk about how the language needs to be clear or more practical. And I just think I really congratulate the advocates, because the hardest thing is breaking through with the general changes that occurred. And now there's a chance to go back and clean it up. So I really hope that the coalition is, still working together and can really fine tune the legislation to be more impactful. Did you have a follow up on that, Ben, or any final points on sort of the legislative process?
No, I mean, that answers my question. I mean, I think that, obviously the A and B felony stuff is really tough. That is, I can imagine sort of, essentially like putting that on the table and having it being something that you have to let go in order to get the other changes. I mean, I think from no risk to low risk is a really big deal. And as Yvette has pointed out, this is, we're sort of in a agency interpretation situation, right? Like social workers have to interpret this in the correct way. But that's where, as Daniel, you were just pointing out, the public sort of education part of this is really important. And I think that we will, just as a group of people who care about this, have to do that and push on the fact that, as Yvette said, there are 3 categories, not one, and it's low risk, not no risk, and just see where the chips fall after we really push people on that.
Yeah, just another thing I wanted to highlight on sort of, what our asks were and what we got. We did get that pushback for the terminally ill folks to a doctor thinks that you're going to, die in 9 months versus in 6. But that was a big thing that we talked about a lot and becomes a difficult aspect because the doctors we spoke to, and we spoke to several, said that often is not something that doctors will feel comfortable signing off on, depending on the diagnosis. I mean, there's some where you can say, hey, people really don't make it past 6 months once they have what you have. And there's others where it can be very debilitating and potentially, but not. And so asking them to, on these forms for this release say, yeah, it's my professional opinion that this person is not going to be with us in 6 months or 9 months is not always an easy call for a doctor to make. And that can be a thing that's really holding the person up. So that's, still something we're dealing with. We got it pushed back from 6 months. But I think, ideally that's something we would have something else there that could meet that same criterion, or not have that be a part of the process is the requirement that somebody medical has told you that you only have such an amount of time to live.
Yeah, I'm so glad that you talked about that, Luke. I totally agree. I mean, we've all had terminally ill folks in our lives, and you're right, it's really difficult to determine how many months, and it is the doctors are often wrong on both sides, right? People die much sooner and people often live longer. But the point we were trying to make, right, is that when someone has a terminal illness and they're already incapacitated to the point that they pose a low or no public safety risk, then does that person really have to have a certain amount of time left, right? I would say no, they shouldn't. They should be able to go home.
Can I pose a question? I saw that Ben's about to leave, and I know ADA Royster from back in the day working with MARs. And so I'm curious, as an advocate, and this is really for Luke at Disability Rights, that I know does some direct advocacy. I'm curious from the Wilson Center broader perspective, but also Ben and ADA Royster. If you're looking at an individual who generally people agree should be out of prison, is still the best route a motion for appropriate relief? Is it to try to get them to fit into a category of extended limits of confinement? Is it to go through the commutation process, or is it now to go through the broader medical release process? And obviously, no, it's case dependent, but to talk about those dynamics, anybody who wants to.
There is a lot of discretion still in terms of the local prosecutor. And so many things can be done, whether it's a motion for appropriate relief or what you're referring to, the other process. However, there's so much involved with politics, and so I will limit my comments at this point. I mean, I've seen these dynamics play out in every day. I've seen someone who's facing stage 4 cancer. Clearly, it was they weren't a smoker. No other risk factors other than being poor and growing up in the inner city, and being in this juxtaposition. And I don't know what the answer is, but y'all got to continue to push.
Yeah, and I can speak to that a little. And pardon me, because my experience with commutation and motions for appropriate leave comes from my time doing innocence work. So I'm more familiar with them being used in that context. But I think whether it's, the I guess it would still be the judge in the county you got convicted for the motion for appropriate relief, the governor for anything involving commutation, or depending which route you go, either the probation parole commission or the secretary for compassionate release. At every point, there is a barrier that you have to deal with, which is that it's not a checklist. You can meet every eligibility criteria, and they still need to individually review your case, and they can still say no. And that's where the advocacy comes in. Having a good advocate at your side who knows what they're looking for. Who can say, this is what I know. This commission, this is what they want to see. Who can just get your case as early as possible to help you work out the plan so that you get in front of the commission before, for some of these folks, their time comes when they're in the middle of the process. So being prepared, being ready, and, unfortunately for all those avenues, you do face, the final arbiter, and there's no guarantee that even if you check all the boxes that they are going to decide that you're, extending release to you through whatever means they can is appropriate. Certainly a barrier, certainly a reason why, we feel people need advocates in this process who are familiar with this and sort of can guide folks through. And also why, the public education, even at this level, can be so important. Making sure that the commissioners are aware of the different statistics about how less likely to, commit crimes against folks are, at this certain age, not just looking at this individual, but looking at this person is not in a big risk group, having an advocate who can look through their prison record and either say, look at their infractions and say, look, we can explain these, or look to their record and say, look, we have, if this person has a really, really sort of clean record, or just know how to deal with either of those agencies. Same way you would drafting a motion for appropriate relief, same way you would making a formal request for commutation from the governor. So that individual assessment and that final authority resting within a body that is, ultimately made up of individuals, and we all carry with us our sort of implicit biases and opinions, but having somebody who can help folks navigate that, I think, is a great first step, so that they can, put their best foot forward and really make themselves as attractive candidates as they can for release based on what they're going through. So, certainly a barrier, getting that individual assessment. And I would argue, at least in terms of the commission, the folks who go through the medical release, they do the medical release final reviews, that might also be an argument to open up eligibility further. Everybody gets an individual assessment, whether you meet all the eligibility criteria or you just met enough to sneak by the first sort of stage in the process. So, my argument would be, hey, if you're giving them this individualized account, it's very detailed. The commission has a lot of leeway to look into pretty much anything. It's a long process. What would then be the harm knowing that everybody gets that with opening up these eligibility requirements a little bit more? So yeah, that's, ultimately you're going to face that individualized assessment sort of no matter what route you go. And there's going to be somebody at the end of the day, or a group of people who make that decision.
Yeah, I agree completely. And just to sort of add another group that we're worried about that is falling through the cracks and will continue to fall through the cracks are people with mild cognitive impairment and dementia and just any cognitive impairment. There are folks in prison who don't even know why they're there anymore and are increasingly not able to do like their daily functions of living without help. And it's not immediately clear that they fit really well into any of these three buckets that we have here. My hope is that, or my belief is that they do fit into really all three of them. um, but not as they're completely written right now. And so I think there has to be some work there. As Daniel said in the beginning, prison population is aging, the world is aging, right? And it is even more exaggerated in prisons right now. So I think that's an area that we need to be exploring as well.
Yeah, absolutely. And as an example, we have my colleague Desiree, who does pretty much exclusively work with TBI, traumatic brain injury. And sort of what we found is um, it's not screened for, at least it wasn't for a very long time. I think DAC might be considering it now. It affects a lot of folks, affects their behavior in ways that would make them get
More trouble.
into, get into the justice system young. And it would also create problems for them when they're in the system and they're just it's missed at screening or it's not screened for. It's difficult to diagnose. Unlikely people would get diagnosed with it in the community, and it can have long-ranging effects that can get worse with age. So an example of the kind of thing where, um, you know, we need to be sort of responsive and have that in mind too. I think people think, yeah, permanently and totally disabled. They think somebody, late stages MS, somebody who needs a lot of physical help getting around, and don't really have in mind the folks who suffer cognitive impairments, maybe for long term and it's getting worse, or maybe is new because of the onset of dementia or something else like that.
I wanted to pick up a thread from the chat. Laura asked about, and please raise up anybody who wants to ask a question. Just raise your hand, and Tim can bring you on screen. But Laura was talking about, okay, if these are the decision makers? Who are they? And Ben pointed out that there has been a significant shift, and some of the advocates from the conversations I remember a few years ago. Those personalities really do matter. When Angela Bryant was appointed to the board, and I think she still may be serving on it, unless she moved to DHHS. No, I think she's on the pro board right now. She was saying that they all sort of work hard, but it is about sort of perspectives. And the guy who had been the chief person on the commission for years, is a former sheriff who was very sort of focused on being cautious. And so there has been a change in the last 2 years. As I understand it, that individual retired last year. I know another sort of younger person. I think it was like Patrick Benroot's daughter. It was a clear nepotistic. Well, I don't want to say that, but it was a powerful politician's daughter was appointed. But those are opportunities to educate individuals, and I'll take an individual who's a well-connected person who's there for nepotistic reasons to be able to educate them on the issue like this. And so just want to open up to talk about any experiences that people have had before that commission or with the individual commissioners. Then also open it up for any questions from the people who are participating in the conversation.
We have one question in the chat for you. We have a question from Jonah. As we were talking about the role of social workers in the importance of assessment, they find it concerning that social workers are the ones who are most involved in these decisions and the ones who have most contact with these people. These social workers work for the carceral institutions. Is there a way to get social workers who do not work for the carceral institution involved with this process? Thank you for your question, Jonah.
Yeah, that's a really great question. Thank you, Jonah. That is actually something that we're thinking about in the coalition right now of, sort of both issues that you're raising. One is that the social workers are ultimately also prison employees. and also that there may not be enough social workers to go around to actually support people to come out, especially as the law has been expanded. So we are in the process of talking with the social workers that touch these cases. The way that it works right now is there's just a few social workers. There are a couple of vacancies, as I understand it, in that unit that works on medical release. And they also bring in students who come in who are getting their master's degree in social work, and they come in for their 1-year placement. So there are, I think, 3 or 4 students right now working on these types of cases as well. And yeah, I think Laura says she knows Greg. I think it's Greg Holloway. Is that who you're thinking of? Yes, that is the head social worker there, and I do believe that he is open to learn and open to change, and while it really does want to do what is right. Yeah, but we are really trying to think about and would welcome everybody's sort of very practical solutions to the challenges. Another set of challenges that was identified by the social workers is that when somebody is eligible for release, then they have to do the planning, right? And they have to do the home plan for someone. And one of the barriers is trying to find a caregiver for that person. And another barrier is if there isn't a caregiver available, is trying to find a facility that will take that person. And so the social workers often will call like all 200 and something nursing homes in North Carolina and finally get one to say yes. And it's hard because there just aren't a lot of slots available in these nursing homes. The social workers are not able to give a really good estimate of when the person would be released and able to move in. And then there are a lot of nursing homes that have restrictions for people who are formerly incarcerated or who have records, and they have a lot of discretion in who they take. And so it's a really, really difficult job for them too. Um, yeah, I would hope that Medicaid expansion will affect this dynamic. As we know, many more folks leaving prison are going to be eligible for Medicaid than have been in the past. And because they're eligible for Medicaid, they will also be eligible for more services. And it could be that their families, if they were to go home, may be able to get more services for that person in the home to better support them. And of course, Luke, you would know much more about this than me. But that's my understanding.
Yeah, I think that's a good overview of it. It's a good thing we're open for positive changes. I will say, in the carceral setting, we do a lot of work in jails too, and it's we'll see about the application. Good thing across the board, but I think what we have a lot of people right now, not just myself, because we do all types of disability work, not just in carceral setting, are trying to figure out and trying to sort of guide as best we can what the expansion actually looks like on the ground. It can definitely do good things, and we're hoping that we can, in the application of it, realize all that good stuff that it can do to help folks both at the prison level and at the jail level.
When I think disability rights always has a unique sort of insight into the prisons and jails because of their sort of unique, statutory ability to get in there, and not just by begging, like a lot of the rest of us. And so, I'm always curious about, there's the sort of there's a policy changes, but it's also about the tone. And so I'm curious, just it sounds like a positive. One, Laura clarified in the chat that's just about Greg Moss, who's a new parole commissioner, or post-release supervision officer. It's a self-commissioner, but and it sounds pretty positive there. But I'm just curious, within the agency itself, Department of Public Safety, now that they're coming sort of out at the other end of this epidemic, we're still out there every December protesting conditions and mass incarceration. I'm just curious if y'all see the tone and sort of the social dynamics and the sort of stigma that sort of allows for the subjugation of people too often. If y'all see that changing within the prisons at all.
All right. I think right now, they are and have been, and this is an issue that predated COVID by a long time. They're still in the middle of staffing crisis, and that's not just prisons, that's jails, that's everybody. I mean, it is significant. It's significant on the medical side. It's significant on the officer side, which then affects the medical side. If there's nobody to take people to their appointments, they don't get to them. That is sort of what we hear from DAC, is that staffing is sort of their number one issue that they say is really holding everything else up. I think on the medical side, we've seen them, I think, start to implement, and this is sort of broader, but some programs that do good for folks. For example, to get folks out of restrictive housing, solitary confinement, they started using therapeutic diversion units. Get the folks with serious mental health issues out of solitary, give them programming, try and get them some help. Those have seen great success. And I think that, we would just like to see the expansion of those programs. So you do have things like that, but I got to say my broad experience with DAC and with the prison system is anybody who wants to try and change it, if that's from the inside or from the outside, faces a lot of institutional momentum to keep that place running exactly the way that it does. Mixing my metaphors there to say there's momentum towards not changing, but there really is. There's significant resistance, and it takes a lot. I think in terms of medical release, opening up the qualifications is the first step, and we have seen their policies start to reflect, the written policies that everyone can access online, I think does now reflect for medical release what the statute is, meaning the DAC, I think is open to trying to use this new eligibility. And I think because they're opening it up and because the change in the legislation makes it sort of a bit of an open issue for them, we can say you've changed this, so now there's new policies going into place. There is an opening here for advocates to really try and set the tone, show them that this can be done, try and show them whether it's through data or through success stories, or sometimes just through getting more people physically in front of the commissioner so they can see these folks and see who they are, hear their stories. You have an opportunity to sort of change how I think they consider medical release and sort of what they're looking for when they're considering folks' cases, or trying to consider whether somebody is disabled enough or less of a risk to be released. So I think you need, what I think we've tried to do is find those moments, find where, it's a huge system. We've got great coalitions of advocates throughout the state on a number of different issues, but it takes a lot of push to get sort of one thing changed. And I think there's an argument that you can change or start to change the overall culture by making individual improvements to these programs where you can. I certainly don't, Danny knows this, and so do most people on the call. I certainly don't think you stop advocacy with just trying to ask for changes in programs that are in place. I think advocacy is much broader than that. But in terms of things to do to change the culture, where you can work with DAC to try and implement new programs that are going to help folks and that they are also behind, broadly, I see more opportunity in that, because then that's something that they feel like they were involved in. Certainly, you have to use other leverage when you have to protect the rights of the folks that you both represent and just the humanity of folks generally. But compared to something like a hypothetical lawsuit where DAC may feel that this is just something they're doing to get because the judge ordered them to do it, if you can make changes and find the small areas where y'all can cooperate and at least create improvements to the system, especially if they involve looking at more people's cases, getting out, treating folks more humanely, and DAC can see that as something that they're also doing in addition to the advocates, because they are, and if they take our advice and everything. So I think you get some opportunity to change the culture that way. And I don't know, I gotta say this is kind of crossing the line into my theoretical musings, because a lot of times in advocacy work, we have to take the culture as it is and advocate around that. or leverage around that or whatever we're going to do. And we hope to see it change. We try and push things that we think are going to make it change. But it's at once sort of solid and also fickle. A lot of it depends on what the leaders within that system are hearing from the top, what sort of tone is Secretary Ishii setting and the folks that are sort of at the top of the organization. And like with anything, culture, especially in that organization, is pretty well entrenched now. And so it's gradual steps. And those steps, if you get leadership who decides to change direction, steps that advocates would consider steps forward towards better culture can get erased pretty quickly. So it's a tough thing, changing the prison culture entirely. I think that small changes, especially if you're talking about something like, educating one of the commissioners so that they now have a background, and getting more folks in front of them so they can hear more of these stories and try and engage a little more empathy that way than just reading about someone on a piece of paper, especially for this population, which society and prison systems generally tend to make invisible. I think those are positive steps that can have a positive effect.
Just want to open the idea of, just any additional, as we move forward with advocacy and, broadly, whether it's to the agency or legislators, just want to hear people's ideas of sort of necessary steps. And, I'll just add one, personalities matter and sort of relationships matter. And so, they matter a lot. And so, I think this is a good example of this was a relationship between coalition partners and Warren Daniel, who was the head of, I guess he wasn't even head of judiciary this session. He was head of commerce, but had a sort of outsized power. And because, in my experience, advocates in that particular coalition and also walked a fine line with their advocacy, right? Like if you're trying to maintain that relationship, a lot of things go into it. First and foremost, they have to see you as honest and sort of, a person of integrity. But beyond that, they can see you as honest and a person of integrity. But if all they hear is criticism from you, it makes it tough to then go back to them and say, hey, can you truly in this situation use your sort of your power and your power alone to make this happen? And so just hoping people can talk about that dynamic and especially in the coalition context, because, as Yvette talked about earlier, different coalition partners can play different roles, not just because of sort of, their resources or their limitations, but also their relationships, also sort of who's going to be the accountability partner and the sort of, the saber rattler, and who's going to be the sweet talker and shit eater a lot of times. And, you just have to sort of pick a lane, and it's hard. And some people can do it. It helps if you have a lot of money behind you. You can shift into different lanes. But if you don't have, a huge corporation behind your money, it really is sort of you have to stand on your personality, your relationships, and sort of your integrity alone. And so it's hard to jump back and forth. And so just wanted to throw that out there. And really, because I'm thinking of I've definitely taken the lane of holding the district attorneys accountable as an association and as a lobbying entity, because, I think people here know that anything that has to do with criminal justice reform, they get a say on this. And so, for the fact that it was in the budget, must have meant that the DAs either didn't oppose it or it was just so low on their priority list that they just chose not to push it. But in my experience, that doesn't mean you're sort of bad the woods. One of the key stakeholders is advocates start to look to expand this, whether it's through administrative interpretation or a change in legislation. The district attorneys feel like they should have a say even on agency interpretation of DPS. And so, it's just very complicated in how you approach this. But just want to open it up for any sort of, as we move forward, what are the advocates and impacted people thinking about, how to navigate expanded eligibility or access, I should say.
Yeah, I mean, I want to hear from others who are here participating, but I'll just say I completely agree with everything that's just been recently said, and Daniel's emphasis on relationships. I think, you our coalition was no different in terms of having all sorts of different relationships and different roles, and sort of different ways of approaching things and different ways of sort of negotiating within ourselves as well for sort of the best strategy and approach. And I think that's going to be really important going forward. And I think we're right now trying to really, sort of approach DAC and the social workers and, all the different sort of players in this with sort of like, okay, we're here to help and we want to sort of wrap our arms around you and think of ways to support you more so that you can support more newly eligible folks to go through this process. And so for me, that's a really important sort of strategy and approach, is to not sort of come out swinging, but rather to sort of come with like, okay, how can I help you to like do this and to actually move more people in front of the parole board. And then I think also with the parole board, like, how can we, sort of very kindly educate them in and show them that, there are actually 3 different categories here. And, yeah. And I think that's gonna, to Luke's point, that is a much slower process than we would like. But something that we have to continue to do.
Yeah, I agree. I think it is slow, and I think those relationships are important to see people as they are representatives of that institution, but that there's a broad, spectrum of views on any given issue amongst the employees and the folks who wield power within that institution. And building that trust can be hard, especially when you're talking about prison advocacy and jail advocacy. These are issues that people feel passionately about, and are often there's a big chasm in between what each side is going to agree is acceptable. I think that is a good reason to work in coalition as a coalition of advocates, because you not only get the resources and expertise of your coalition partners, but you get their relationship. You get that certain people can call other people and get their phone and get the call picked up, whereas I can't. And I think there's the relationships, and there's also just trying to keep your ears open for when anybody on the other side is going to tell you sort of what they want. What do we know that the institution and DAC as a whole is after, and how can we have our goals combine in that way, right? Like, we knew that maybe while a plea to the humanitarian nature of having somebody die in their own home, or at least in a hospital surrounded by loved ones, versus in a prison cell by themselves, it might ring some people's hearts, but that might not necessarily lead to change. So we have that, and we know DAC, they're going to try and stretch their budget as far as they can, just like any other organization. Here's how this will save you guys money. You're having a staffing crisis of nurses and medical staff. Why not take these folks who are low risk, who are taking up a huge number of nurse and doctor hours, and send them out? Saves you money, and and for the cost of really just keeping track of them through the parole system, you can also free up a bunch of resources that way. So just a lot of times in a lot of the conversations, I think they can get heated. Folks are passionate. It can also feel like each side is just talking past each other because what you want seems so far away. But just trying to keep in mind what are our relationships in the coalition with this individual person and issues we know that they care about, and the same goes for the institution. What do we know that they always want to do? What if they signal to us might be things that they are willing to work on and put effort into, or versus what are they not? And trying to find where that overlaps, and where you can show them that overlaps, to at least try and have whatever you're putting forward serve some common goals. And I think I like to think, because we did a lot of research to do it, that we did that here, and that along with the personal relationships with the senator, when the senator went back and talked to folks, whoever they had to, and they had that backing. They could say, look, here's what the data says. We got the data. This is something that I'm interested on, on a personal level. And also it helps DAC do the things that it wants to do: save money, free up nursing, take resources that they're having to focus all on one person and spread those resources out to folks who don't need as much, but you can reach more people. And I think when you've got that combination of the personal connection and also speaking to the needs of the institution, that's when you can be sort of the most effective in trying to get your advocacy done. Or what at least you can aim for. Who knows what can derail it? Any number of things, but I think if you try and start from there, you can start from a good base and work towards common goals where you can find them.
And then I did want to mention some action that was taken by the governor today, just quickly highlight that. And it talks about these dynamics, and I think it's a good way to sort of tie this conversation back to the Vigil for Freedom and Racial Justice. That, as I think Luke said, we want to provide sort of all the tools we can to decision makers, but the ones they already have are severely underutilized. And there's sort of a broad reluctance to use discretion in a full-throated manner with the urgency people on this call would feel that it deserves. And that's from a Democratic administration, and so I think a big part of the Vigil for Freedom and Justice, again, part of this is with different coalition partners taking sort of different lanes and different degrees of their sort of education and criticism in some cases. But I do think broadly what all advocates are saying is we have to decarcerate. We have to this is a crisis. This is not normal. And this has to be given the political weight that it deserves. And unfortunately, we're still on the fence. And so the news today, which I got on my soapbox instead of announcing the actual news.
No, go ahead. It's an important preamble.
Is that it's, there was relief granted today. There was one commutation that allowed a individual that was convicted, I think at age 17, and had served decades in prison. That individual is about to be or has already been released. And so that's anytime commutation is used, that's sort of the highest level of relief, in a sense of that's the governor really saying, I'm releasing this person and, taking accountability if they end up doing something. And so we see that the least, but are always glad to see it when it does occur. And then the other thing that occurred was there were 4 pardons of forgiveness. And so that's individuals where basically it goes toward collateral consequences. It goes toward this sort of broader conversation about who somebody is. And so it's, it's more, there's not a lot of legal functions to it, but it is important. And so I want to specifically highlight that one of our colleagues, a longtime member of the Second Chance Alliance, Portia, was one of the individuals. She's worked at the legislature as a legislative aide for years, had actually published a book that she's been touring for, talked about how to pass legislation at the state legislature. And so just really glad that her and her young growing family got that recognition from the governor. But the fact that it's only 5 individuals out of tens of thousands, at any point, at any day being incarcerated, and then obviously hundreds of thousands of others having collateral consequences. 5 is, I'm grateful, as we say, for those individuals and what it means for those. But it's really an indictment against the system that that broad power is so underutilized again this year.
And I don't want to, and congratulations, and we celebrate all 5 of the folks who are going to be released or forgiven by the governor. And I don't want to minimize any of that, but I also just want to point out that the governor has released only one person, the person who received commutation under the Juvenile Sentencing Review Board. And that's one person the entire year. So I just want to point that out so that folks know that that is a very low number compared to the folks that were have put in their petitions and requested commutation from the Juvenile Sentencing Review Board and the governor. So yeah, I won't take a lot of time. I just want to echo that this is indeed a crisis, and a crisis that's just going to get worse and worse over time as our country continues to age and our prison systems continue not to be decarcerated. So this is something that I am just really glad we're having a community conversation about, and I feel really honored to be part of this fight. So thank you so much for having me.
Yeah, thanks for having me as well. And I guess the one last thing is that these community conversations are really important because public attention to these issues of people in prisons and jails is really important. Like I said, the nature of the system is to keep these folks kind of unseen and sheltered away from prying eyes of the public. So the more that people start to care about this, start to make this an issue for them in their life, or that they keep track of, I think makes legislators take notice, because they start seeing that their voters might vote based on these types of issues. And I think can even make a difference in DAC's calculus, because whereas maybe they would only see risk in letting somebody out and trying to ameliorate that, letting them know that there is, members of the public out there, and hopefully a growing number of them who are behind these kind of releases, might weigh on the other side of the scale for them when they're considering the release of either broad policies or the release of individuals. So I think public attention and conversation about these types of issues is incredibly important to the work we do.